Hello and welcome to AWCI's Convention and Intex Expo Reconstructed. Today's presentation is Navigating Uncharted Waters, Getting Back to Business and COVID-19. I am Anne Marie Silvatelli, AWCI's Director of Education, and I will be your host for today's presentation. Before we start, a few housekeeping items. All attendees should be on mute during today's presentation. However, we ask that you please mute your phones or computer microphones as well to ensure that we keep a clear line for our presenters. Should you have a question at any time during today's broadcast, please submit it by using the question box in your GoToMeeting dashboard. And we'll have a brief question and answer at the end of our presentation, and we'll make every attempt to get all of your questions answered. And the handouts are also available for you to download in your dashboard in the handout section. So presenting for us today are Rich Caprio and Eric Coleman. Rich Capriola has extensive experience representing subcontractors and owners in all manners of construction issues, including delay claims, liens, bonds, negligent and defective construction, prompt pay claims, and related construction litigation, arbitration, and mediation. He is licensed in Georgia, New York, and Washington, D.C., and through association with local counsel has represented clients across the country. Eric Coleman serves as a board member for the construction section of the Atlanta Bar Association. His clients include owners, general contractors, and subcontractors, both large and small. His practice focuses on resolution of construction disputes, including delay, non-payment, and defective construction claims through mediation, arbitration, and litigation. So thank you, Rich and Eric, and I will turn it over to you.
Thank you, Anna Marie. And Eric and I thank you all for tuning in and joining us on this webinar. This is our second webinar. We gave one probably a little over a month ago now, and it seems like a world of difference between the realities that we were just entering then and where we are now and what's become sort of the normal. I think we've all had too much news intake lately, too many press briefings by politicians and scientists, and we probably just want this all to be over, but the reality that I think is settling in is that it's going to be with us for longer than any of us want, and it's uncertain as to what will ultimately prevail as the new normal or when, and part of what we wanted to do today is to give a current update on what we understand to be the latest coming in terms of the legal impacts on the subcontractor industry and our trade group here. So Eric's got the controls for the PowerPoint. We're separate locations working out of our homes respectively, as I imagine many of you are as well. So Eric, if you could change the first slide. Okay, so AWCI was good enough to share with us some recent surveying they've done of you all, the members. And a couple points that I wanted to highlight here are, on average, on a scale of 1 to 100 as to the impact that COVID was going to have on your businesses, the response was right in the middle. People said, it's about a 5 on a scale of 1 to 10, which was interesting. And then you compare that to the next response. How is COVID going to have do you think COVID is going to have at least a significant impact on the industry? 2/3 of you said yes. So a little more optimistic, maybe with your own business, but seeing a broader impact to others. 50% believe work will be interrupted for at least 3 months, and 80% have implemented social distancing, 90% increased use of hand sanitizers and hand washing. And I have to imagine that those are going to approach 100% soon. And also, there's 20% have a sick leave policy in place and plans to expand. I thought those were interesting comments from your trade group as to what the current feel is out there. Next page. In terms of the national look as to what's going on in the construction industry, and this was updated about a week ago, and we all know that it's fast changing, so it could be different. But for the most part, construction activities have been deemed essential and allowed to resume, despite a few exceptions here and there. So all the country that you see in the darker blue is essentially, I should say, is where construction is deemed essential and activities are proceeding. Now, there's restrictions on those, and we're going to be talking about some of that in today's presentation. And there's a handful of states where there still is uncertainty. New York and New Jersey, sort of the hotbed of the pandemic, coming on the downside of it now, hopefully. The ability to do construction work seems to be a little more uncertain there than it does in other areas. Michigan is another one where it appears that we're on the cusp of reopening some of the construction activities in Michigan based upon the sources that we have. So, overview on the next page. We're going to talk about the projects that will be reopening and the safety measures going forward, how these issues will affect your businesses, what safety measures you need to comply with, what do you do when you have a sick employee, COVID-19 sick employee, how do you remain productive with the restrictions in place, what are the potential insurance issues that are surfacing as a result of the pandemic, addressing generally supply chain issues, talking about contract provisions. We're lawyers, we always talk about contract provisions, and those are the governing documents on your jobs. And then also, reminders to make sure you're doing enough of documentation of issues and your concerns on your jobs with your other parties to your contract. Next page. So subcontractors have a duty under most of the contracts that they enter into to comply with safety laws and requirements. It's sort of one of the things that we never really took much concern with when we thought we were talking about making sure that workers do their work safely, use harnesses, comply with all OSHA requirements in terms of performing construction work. But with the new overlay of pandemic, these provisions and the language in them have potentially different meaning, and it'll be interesting to see how they're applied. But as subcontractors, we want you to be aware that the language is in probably all of your contracts with any significant general contractor. So the language in the first example that we have here, the subcontractor agrees to comply with all federal, state, municipal, and local laws, ordinances, rules, regulations, codes, standards, ordinances concerning safety that are applicable to the work. And when so ordered, the subcontractor shall stop any work which contractor deems potentially unsafe, non-compliant, or a violation until corrective measures are satisfied. And the subcontractor agrees that it will not have nor make any claim for damages growing out of such stoppages. So looking at that with COVID-19 in mind, arguably the subcontractor under this document has the obligation to comply with all safety requirements on its own to make sure that the work is performed according to the requirements for protection from pandemic now, and any costs and expenses that you incur to do that cannot be brought back against the general contractor. Our read is that that language was never intended to reach to a pandemic. And that would be the argument that would be made if there was an effort to shift 100% of the cost to subcontractors. But the language is there. It's just good to have that in the back of your mind as you're looking at, and we're talking about these guidelines that are starting to come out and that are already in play. Next slide. So the CDC published some interim guidelines for construction workers on April 20th, so about 3 weeks ago now. The guidelines are how to allow construction workers to continue to work if they've been exposed or potentially exposed to someone with COVID-19. Potentially exposed in this context means that someone in the household has COVID-19, or they came in contact, meaning within 6 feet, of someone with confirmed or suspected COVID-19. So that's a person who is potentially exposed. And that potential exposure has to have taken place within 48 hours of the person becoming symptomatic. So the person that they were exposed to becoming symptomatic. Next page. Potentially exposed workers, they're allowed to continue to work if they're non-symptomatic. And we hear a lot about COVID on how a large percentage of people who have it may not even know they have it or have very mild symptoms. So if they're non-symptomatic at all, they can continue to work. But supposed to have to take their temperature regularly and make sure that their symptoms are not showing before entering a work site. The employees are to self-monitor and be supervised by someone who's responsible for making sure that these guidelines are being followed. And maintain social distancing of 6 feet. We've heard a lot about that. I'm not sure where the magic number 6 feet has come from, but it has stuck throughout all of the regulations, guidance, and requirements that we've seen. So 6 feet is the magic number. And those people are required to wear face masks at all times, and those people being the potentially exposed folks, for 14 days after the potential exposure. And there's a cleaning regimen required for all surfaces and equipment that they come in contact with on the job site. So they're allowed to work, but there's stringent requirements that go with it. Next page. When an employee does come to work, when an employee becomes sick, they should be sent home immediately. If they're on the job site and they're evidencing any of the symptoms of COVID-19, and we've all heard that that is fever, cough, soreness, sort of general flu-like symptoms. The workplace where they were at should be cleaned and disinfected. Anyone who came in contact within 6 feet of that person should be considered potentially exposed and monitored. And there should be a list of all the people who came in contact with that person maintained. This gets into that whole contact tracing thing that we're hearing a lot about. So the CDC is wanting employers to help monitor the contacts so that if it should prove to be a positive COVID case, they have a step up on trying to track down and contain that spread. Next page. Some things to keep in mind that the CDC has told us: don't share headsets or other objects that come into contact with the face or mouth. I think that probably goes without saying. Think about a couple extra items like telephones. You know, you're talking on the phone and you want to hand it to your buddy. Don't do that. Use speaker. Or if anyone still uses a camera to maintain photos on a job site, don't be sharing the camera. Most of us use our phone, I think, today. Staggered breaks, if possible, to reduce how many people are congregating in break areas and break rooms. Don't share food utensils. Consider a ban on carpooling. That's one thing that I've heard some clients talking about, is preventing employees from carpooling and coming to work in carpools, because obviously you can't keep the social distancing, and we don't want them showing up and spreading disease at the job site. Staggering the shifts and stocking personal protective equipment, PPE. And that could be difficult to get your hands on, but the obligation is on the employer to make sure that you've got masks, you've got gloves for employees who need it, hand sanitizer, proper cleaning agents. We'll be talking about some of that. And requiring masks and gloves where appropriate to protect and prevent the spread. Next page talks about OSHA. OSHA has come up with some guidelines. And interestingly, when you read these, they go out of their way to say that these are guidelines. These are not mandatory at this time. They don't take away from anything that OSHA has in place otherwise. So all the OSHA guidelines remain the same, but they've added to it this alert of April 21st. So again, just very recently. Some of the things are similar to what we just saw with the CDC. Encourage sick workers to stay home. Training on the proper use of masks and other PPE. So, make sure that someone's watched a video and observed how to properly fit a mask, and then train your folks on how to do that. Avoid physical contact and social distancing, 6 feet again, even if you're in the trailer. If hand washing is not available, then got to have alcohol rub of at least 60% alcohol available. Use EPA-approved chemicals, and there's a list that we'll cite later that identifies the chemicals that are on the EPA-approved list, and there's a link to it in the presentation. And encourage reporting of safety and health concerns. So make sure that folks who are in your organization and feeling sick are reporting that openly and welcome that reporting. You want to catch it as early as possible if it's going on, and make sure you get it out of your organization as quickly as possible and out of the potential of spreading. Next page, please. So OSHA has also recommended the development of a written infectious disease preparedness and response plan. And there's some talk that they're going to make this a requirement going forward. Right now, it's just a recommendation. And they give us some guidance on what that should be. There should be a process to stay abreast of guidance from federal, state, and local health departments. So have someone who's tasked with that responsibility. Consider and address level of risk for job site in each job task. So you've got 10 jobs you're working, and you're doing exterior finishes on some of them. Well, that's a different level of risk than if you're working in and finishing out a office that's being occupied by multiple trades, for example. And there's different tasks too. So someone who's working on a job in close proximity inside, finishing sheetrock, may have a different exposure risk than the guy who's out there staffing the laydown area and working solely or working with someone at a long distance away. Again, they're different risk exposures. Evaluate the source of exposure between coworkers, other trades, public. So where are the sources of exposure on your job? Are you working in an active airport, for example, if anyone's still in airports these days? Are you working in a public space? Develop a contingency plan for absenteeism, reduced operations, social distancing, supply chain disruption. So OSHA is saying, take into account that things may not be running regular for a while. You could have heightened absenteeism. You might be not running at 100% steam on jobs or able to staff a job fully. And you might run into supply chain problems. We're going to address all those in this presentation. Develop a plan to comply with infectious prevention guidelines. So that's implementing the PPE and making sure you got your distancing in place, the things that we've talked about. Next page. So what to do at your job sites, some general considerations. Make sure you got managers and supervisors who are familiar with all the safety measures. Make someone in charge on the job site whose responsibility is, on top of everything else they were doing before this, is to make sure that they are aware of and implementing these safety measures. This helps to centralize any concerns or questions that your team has as to what to do. They know who to go to with that question instead of asking people who may not know and may not be well informed. Designate a person to be the monitor on the site of the safety. That's probably the same person who's going to be the person responsible for it. Publish a list of important requirements on the job site for each referenced employee. So everybody on that job site should get a list of the procedures on that job site that are to be followed. I went into my office the other day, for example, and we were running at, about 20% staff. And I knew going in that I was supposed to have a mask on and to wear it at all times in common areas and to wipe down. So I knew what to expect. We want your employees to know what to expect when they enter a job site. Do they have to wear a mask? Do they need gloves? All those things. Tell them and provide for them a list of the symptoms for COVID. Help spread the word as to what that entails. So they can be aware of it and can help identify it for you. Show them where all the hand sanitizing and the cleaning and the PPE is stored and make sure it's available to them. We do have an obligation to provide the PPE, personal protective equipment, for our employees. Wear gloves and masks at all times if possible. Can't always be possible, but when possible, have those gloves and masks on and enforce it. Temperature check employees if you have the capability and you can get some of those thermometers that read from a distance. Do some temperature checks of employees when they enter and leave the job site. That's going to become the new norm coming in and out of public spaces. If what they're doing in China is any indication as to what's coming this way and what's already being talked about. And document all your measures that you're doing. Put it in writing. Don't just do it at group meetings, discussions, or phone calls. And I shouldn't have said group meetings because group meetings are a thing of the past right now. You're not going to be sitting in a room with everybody together. You're going to be doing it by conference call, or people are going to be separated at a good distance outside somewhere. Next page. Entering or visiting a job site. If you're working in an occupied building or a residence, check with the manager or the owner as to what their policies are and what the building's requirements are. Continue to sanitize and clean all work areas upon arrival and throughout the day. So what that means is when you get to a job site, there needs to be a process to immediately work on cleaning all the tools and equipment and everything you guys are going to come into contact with, and the same thing on the way out at the end of the day. May need to remind the occupants of the building or others that aren't in your direct employ that you need to maintain the social distancing. It's not going to be the first thing they want to hear, but you need to keep those 6 feet. Limit visitors to the job site to only those that are necessary, and screen visitors as you would by asking questions for COVID-19, any exposure, any fever. Deliveries, to the extent possible, the driver should stay in the vehicle, or if the driver's unloading it, then your guys should stay away from the driver. Next page, please. Cleaning and disinfecting. we talked about this, but regular housekeeping, and that should be not just one person's job, but everyone's job. Trailers and break areas, clean at least once a day. Employees should be provided with the PPE, personal protective equipment. And here's the, make sure you're using the EPA listed List N approved disinfectants and cleaners. And that is the location where you can find that information. And we'll publish this through AWCI. These slides are available to you to download as a PDF, so you'll have that. Collecting trash regularly, latex gloves on. Toilets, make sure someone is cleaning those. You got the vendor coming for the porta potties and cleaning them regularly. Wiping down steering wheels, shift columns, things like that on any of the machinery that's being driven around. And maintain a list of the cleaners and disinfectants that you use and the schedule that you use to do your cleaning, documenting your efforts to protect against any potential exposure and to make sure people are doing their job. Eric, turn it over to you now.
Thank you, Rich. So next we're going to talk about what do you do if you have an employee that's on site with COVID-19 symptoms, and then after that, what if they actually have a confirmed test? And there's a couple of overarching themes to keep in mind during this. Obviously, first and foremost is the health and safety of your workers, your crew, your employees. You always want to give that top consideration. But keep in mind that there's financial consequences as well that can stem from an outbreak on the job site. And those could stem from an immediate reduction in your own labor force that could make it difficult or impossible for you to meet your contractual obligations and timelines, et cetera. And that can present some problems for you. And then God forbid your employee or someone that was working for you, a sub, were to be kind of the genesis of a job site-wide infection, that could even trigger other portions of the policy. And one of the ones we talked about earlier was the obligation to abide by health and safety guidelines. And we don't know how any of this is going to come out because it's all so brand new, but it's not hard to imagine a situation that might occur where an outbreak happens on a job site because a subcontractor wasn't doing what that subcontractor was supposed to do under CDC guidelines. Next thing you know, half the job site is sick, God forbid worse. And all of a sudden, all the fingers are pointing at you as the sub for not doing what you were supposed to do and not documenting that accurately. So what do you do? If you've got an employee with COVID-19 symptoms, fever, difficulty breathing, flu-like symptoms, et cetera, you want to get that person off the job site immediately. Send them straight home, tell them to self-quarantine, and they shouldn't come back to work until they've been symptom-free for at least 72 hours without any sort of fever reduce or anything like that. That's how we know that whatever that contagious period has hopefully passed. And then we want to make sure that we're paying careful attention to everyone else that they came in contact with after that. Rich mentioned earlier those no contact temperature checks. I think that's something you need to go ahead and procure as soon as you possibly can. Have it ready, have it on every job site so that if something like this happens, and you haven't already implemented temperature checks, you can start it right away without any sort of delay. And those, you've seen them on TV, I'm sure they exist, where you can just kind of get in proximity and point them sort of at their forehead or neck, and it reads their temperature and there's no contact. I think that's a wise piece of equipment to have on every job site. And you want to make sure that if the people they've come in contact with, that they know they've come in contact with them. And you got to balance that with that employee's right to privacy. So we don't exchange names and all that sort of stuff, but we say that it's happened. And we say that because we want to make sure that those people are aware that they need to be self-monitoring, and that if they start to have cold and flu-like symptoms, that it's not some minor thing. It's a big deal. We need to know about it. We need to take action. It also makes sense, I think, to communicate early to your workforce what your policy is on COVID-19 leave. During our last webinar, we talked about some of the new rules and regulations that are in place in terms of mandatory leave and how those play out with what percentage of unemployment they're entitled to and all that sort of stuff. But if you're the type of employer that's going to say, look, I'd rather pay my guys 2 weeks worth of their regular pay if they are symptomatic to get them off the job site and avoid any possibility of infecting the rest of my crew and others, then communicate that to them early so they have a level of comfort when they come forward that they're not going to lose their livelihood if they early report symptoms, because you want that information as early as possible so that you can take action on it immediately and avoid it spreading among the job site. So that's what you do if you've got symptoms, if you've got a symptomatic employee. If you've got an employee that's actually tested positive, obviously immediately go home and self-quarantine. In this case, we know we have a confirmed case of COVID-19 if they've been tested and they've reported that back to you. So we want to make sure that they stay away from the job site for at least 7 days since their first positive test. And if they don't have any symptoms, in other words, they tested positive because perhaps they were in an exposure group that got tested but they were asymptomatic, then number one, we want to make sure that it's at least 72 hours with no symptoms, and that's without the aid of any sort of fever reduction medication, just symptom-free. And at least 7 days have passed again. And then any employees that they've come into contact with, again, if we have a confirmed case of COVID-19, the employees that have been in contact with them need to be sent home for 2 weeks, whether they're symptomatic or not. Anybody that they've encountered, we want to get them off the job site so that they don't spread anything. You also want to communicate this information to the GC or to your first-tier sub if you're a lower-tiered sub. You can communicate it to them again with respecting the privacy of the individual, but sharing that information so that they can take appropriate action as well, and so that you can let them know that it's something you're taking seriously and that you're proactively addressing. The construction job site is likely a particularly dangerous place in terms of infection. You've got crews doing manual labor. They may be out of breath, breathing extra hard. They're likely shouting either over distances or over the loud noise of construction equipment. And all of those things combined together, not to mention the close quarters that often happen, that are unavoidable when you're doing work, those are going to increase the possibilities and the opportunities for disease transmission. And so you want to keep that in mind, and you want to be super vigilant about making sure that if any of these situations come up where you've got someone symptomatic or that has been exposed, or certainly that if they've got a positive test, that you do everything you possibly can to protect the rest of your crew and the rest of the job site from spreading that. OSHA reporting. So there's been a lot of questions about if a COVID-19 case, either confirmed or suspected, comes up on a job site. If a worker comes down with these symptoms or comes down with the confirmed case of the disease, what do we have to report as the employer? And some of this has never changed. I mean, if you've got an employee who we know got sick from an exposure at work, that's reportable. Any work-related illness that results in a fatality or hospitalization's got to be reported. However, OSHA is only considering confirmed cases of COVID-19 and illness that requires reporting. So in other words, the fact that other employees may have flu-like symptoms or may have other types of symptoms that are characteristic of COVID-19, it's not really reportable to OSHA until it's confirmed that it was COVID-19 and that we have a reasonable suspicion that it was contracted from a work-related contact. Workers' compensation claims. Similar here. The insurers report that they haven't yet seen an increase in claims for workers' compensation that are related to COVID-19. And that may be due to the fact that they haven't come through yet, or it's more likely due to the fact that the social distancing measures that have been in place for some time now have stalled that spread, but we anticipate seeing some of that coming out in the coming months as things start to return somewhat to normal. Workers' compensation is going to cover injuries or conditions arising out of or in the course of employment. So again, if this is something that they contracted or contacted as a result of performing their job duties, workers' compensation could come into play. There's all sorts of statutes in different states that may exclude communicable diseases from that type of workers' compensation coverage. But I can tell you there's at least one case pending that I read about in the past week where an employer contracted COVID-19 and has claimed that it was as the result of his employer not implementing adequate CDC guidelines to protect him from exposure. And as a result of that, sued not only for workers' compensation coverage, but also for willful and wanton conduct that led to the injury, which subjects the employer to direct liability in excess of what workers' compensation would cover. So we only expect to see more of that coming as things open back up. Insurance issues. It probably comes as no surprise to anyone that the insurance companies are denying these claims. The insurance companies reported that they've seen more claims arise out of this COVID-19 pandemic than they saw out of the 9/11 catastrophe. And there's a concern that's kind of rumbling in the industry that the insurers may not have enough money to pay all these claims if they wind up being forced to claim them, to pay them. There's legislation that's working its way through various states. New York, New Jersey, Pennsylvania have some in place that they're working on. And there's others that are coming up in Ohio, Massachusetts, South Carolina. And we expect to see more of that as this progresses. And what that legislation is aimed at doing is forcing insurers to pay typically a business interruption loss for this COVID-19 pandemic. So kind of the background of where this legislation and where this dispute is coming from. Back in 2006, the ISO, which is the group that drafts a lot of the standard form language that works its way into insurance contracts, drafted an exclusion that excluded from business interruption insurance and other property loss claims, claims that arose out of viruses, bacteria, communicable diseases of that sort. And the argument that is being put forth and kind of making its way around the insurance community is that the information that was presented to state regulators when that exclusion was approved wasn't entirely accurate. These insurance policies depend on a direct physical loss. And that direct physical loss in its most common sense in terms of business interruption would be if you owned a restaurant and the restaurant burned down and it took 3 months to rebuild, you would have business interruption coverage for that 3 months of lost revenue. Well, a virus is obviously a very different thing, but not necessarily with a different effect. If your business was unable to generate revenue for a period of several months as a result of the virus, the insurance companies are going to argue that there was no direct physical loss. There's no property damage. There was nothing in place there was nothing damaged as a result of this virus that prohibited you from using it in the normal way that you would to generate revenue. And that's where the legislation comes in to kind of force their hand on that. And that's still very much in progress, and we don't know how all that's going to shake out, but it'll be something to keep an eye on. So what should you do? Well, take a look at your insurance policies, talk with your insurance agents, your brokers, and get an idea of what's in your policy and how it may apply. You want to make sure that you've got an idea of what the time frame for coverage is and also what your time limits are for making claims. And in many cases, it may be appropriate to make a claim even if we know more likely than not, based on the current status, that claim may be denied and likely will be denied. There is, in many cases, still some value to putting that claim on the books in the event that future litigation or legislation changes the interpretation of those policy terms. You also want to make sure that you're making the claims and that you're doing a full report and a full documentation of what those losses were, when they started and when they ended, so that you have a fully supported claim. And that way you avoid making multiple claims over a period of time and having to face multiple deductibles. We talked briefly about the business interruption insurance. Again, this is a policy that you have in place where if you're unable to put an insured piece of your property to use, to its normal use, because it was damaged by a covered peril, which means by like some kind of covered event, then the amount of money that was lost during your inability to use that can be recovered through insurance. And that's where these unique arguments come in about COVID-19 and whether a virus causes physical damage to property or not. And then there's another type of that called extra expense insurance, which again, it goes to the same thing. It involves a direct physical loss, but instead of it being lost revenue, here we have increased costs. And those costs could be things like employees working remotely and other costs incurred with spreading people out and all of the various elements that would come up here. But again, these are all going to be mostly excluded as the policies are currently being interpreted by insurers. And we just don't know how that's going to play out through legislation or through the courts if it gets to that point. Civil authority provision, again, similar. This is a portion of your insurance policy that would provide coverage for business interruption, lost revenue, extra expenses that may be incurred as a result of a civil authority order that prohibits you from doing the work that you would normally do. Now, at first glance, that seems like that's clearly applicable, especially in those jurisdictions where construction was shut down by the civil authorities. But again, these policies are tied into direct physical loss, and the typical application of a civilian authority policy provision would be if the building next door catches on fire and it renders your building unsafe, and therefore you're precluded from using that facility for some period of time. That's what it would normally cover. This is all so new and so strange that we just don't know how this is all going to come to play out. So moving away from insurance issues and turning back to some more practical issues, as you return to the work site, you may face labor shortages that may affect your ability to perform your contractual obligations. Those could be due to workers who are sick or who are caring for family members that are sick, kids out of school, workers who relocated during the stay-at-home orders. Perhaps they've moved from a more restrictive jurisdiction to a less restrictive jurisdiction. Perhaps they have moved from a job site that was shut down to another one that happened to still be open, or they've moved on to some other type of critical infrastructure work. This is especially true with your labor force. So just because you've got a green light to move forward doesn't necessarily mean that you can staff the project the same way that you bid it. So, what we recommend here is that as you begin the ramp up, and even before that, start getting in touch with your workers, start getting in touch with the labor force, find out where they are, what they're doing, what their availability is, and track all this information so that you can make realistic plans. You can find other alternatives where you need to. If it turns out that your workforce has been impacted so substantially that you may not be able to perform anywhere close to what you obligated yourself to before this, then that's when it's time to start thinking about putting the GC on notice under the various contract provisions that we'll go through in a minute. In terms of job site stoppage, with some of these projects have been unmanned or skeleton staffed for a long period of time. So we want to make sure as soon as we get back to the job site that we take note of work that's been completed, take note of any damage that's occurred, look at inventory, make sure it's all in good shape, and take action on things that need to be corrected or brought back up to standard as a result of the delay. we want to make sure that whatever inventory we had on site and that we've accounted for already and perhaps even submitted payouts for, that we re-inventory it, make sure everything is okay. We want to check our work for vandalism and water intrusion and other types of things that may have occurred due to the humidity exposure, things of that nature. And all of these issues need to be addressed through notices, change order requests, et cetera, to make sure that we've documented extra costs and problems that the subcontractor may face through no fault of their own. We want to take a careful look at the schedule and be very hesitant to go forward with the GC's idea of, well, we're just going to ramp things back up and we're going to scramble back and cover time here. We talked about this during our last webinar a month ago, but at some point, some of these projects that are delayed, there's going to be finger pointing at the end, and you want to be the one that's got the documentation, and you want to be on top of it, and you want to start that right away. And it begins with making sure that the schedule is updated and that the schedule is realistic. And if there's any problems with the schedule, or if the schedule as it's currently drafted is just unrealistic, then you need to ask for a change order to get a schedule in place that you can actually comply with. You may face some other production issues, things that may slow you up, such as safety measures and staggering shifts, social distancing, all these other things that we talked about that may impact your time and your ability to get the work done on time. Keep track of that, have an idea of it beforehand, ask for change orders where you need to. What do you do if you've got inconsistent safety requirements? If you've got a safety implementation within your own company that's consistent with CDC guidelines, and the GC is working off of something different, a lesser standard. Keep in mind that those obligations typically flow to the subcontractor, and we talked about that in the beginning. You need to be firm on that, and you need to the extent that you're forced by a GC to deviate from that, you need to be well documented. Supply chain issues, this is something we've heard from briefly from some of our clients, but it doesn't seem thus far that there's a huge disruption, but there is some. 30% of materials are coming from China. A lot of that's was already being sort of resourced domestically due to tariffs. But again, you want to make sure that your materials, just like your labor force, are able to meet your demands when things reopen. You want to start checking on that early, making those phone calls, and if you need to find alternatives, alternative suppliers, or an alternative product, then you want to be proactive in seeking approval from that before it causes a delay to the project. And Rich, I'll hand it back over to you.
All right. Right now, as we're going to dive in just for a few minutes into the contract provisions. And what we've done is we've looked at contracts, got a stack of contracts that we've reviewed over the recent term with some of the major general contractors that our clients are working with to see what type of terms are in there, so we can give you sort of an overview of what we're seeing as our view of the industry standard in some of these documents. So we're going to be talking about force majeure, which we talked about briefly before in our last presentation, act of God, that is. And we're also going to be talking about documenting and making sure that any impacts you're experiencing and needs for time extension are timely noticed. Over and over again, you'll see language in these contracts that says failure to timely provide notice is deemed a waiver, and courts do impose those. Not universally, and they look for ways around them often, but they do impose them in large part. And notices have to be in writing, and notices can be things for requests of time, delay, notices of extra cost, or notices of unforeseen circumstances. And some of those are particularly pertinent today. Turning to force majeure. Force majeure, act of God, is basically an unforeseen circumstance that prevents someone from fulfilling a contract. Has to be unanticipated event that you are unable to anticipate and unable to prepare for. There has to be no human intervention. Has to be a natural occurrence of the act, and has to make performance impossible or at the very least impractical. So looking at that and applying it to COVID, it appears from at least a good height that COVID is something that no one could reasonably have anticipated, certainly not the impacts it's having. It wasn't human-made, and it is something that when the government says they're shutting down your job site or you're unable to work as you had been and anticipated by the contract, makes performance at least very impractical, at least on the terms and under the specifics of the contract that you may have had pre-COVID. So read them, understand what you've got in there, and also beyond the contract, because as we'll see in a minute, construction contracts have a version of force majeure language that is sort of unique to construction. It's not a typical force majeure provision. A typical force majeure provision would say, when an act of God prevents you from complying with your contract, you can cancel this contract and you're not deemed to have breached it, or you're excused from having to perform fully under the contract due to the act of God, i.e. a flood, a wildfire, something that prevents you from performing. Construction has taken a little different bend on it. That language isn't in there, but that language may be in your state legislation and state statutes. They often have language that provides an act of God type defense to contract performance that's implicit in every contract. So understand what your state laws are if you're running into a situation where you just can't perform under the contract because of COVID. Flip to the next page. Here's a typical force majeure provision, and this is where we highlighted everything, thereby highlighting nothing. So I'm guilty for over-highlighting here. In summary, should the subcontractor be delayed, obstructed, hindered, or interfered with in the commencement or prosecution of its work by any cause, including by any extraordinary condition arising out of war, government regulation, or by any other cause beyond the control of and not due to any fault, neglect, act, or omission of the subcontractor, then you shall be entitled to an extension of time. So if you run into a problem and it's not because of anything you've done, but it's because of a government regulation, for example, i.e. shelter in place or unable to work as you have been, and it's or due to other causes beyond your control and not your fault, then you can be entitled to an extension of time. And that's where the difference is. These contracts all talk about, hey, if you run into an act of God situation, you can request an extension of time, but you can't get out of the contract. And it doesn't excuse your performance otherwise. But like with all things in these contracts, you have to notify timely. And in this contract, you have to notify the general contractor within 48 hours of the commencement of the condition that prevents your performance. So if you have jobs and you haven't provided a notice yet, read your contracts and send those notices out. And you have to demonstrate that you've taken every effort to mitigate or to limit the harm that you're suffering. And if you don't do any of the above, subcontractor expressly waives all rights with respect to any such cause and cause of action for which notice hereunder was not provided. That's a pretty typical provision. The next page has the AIA form document, which really doesn't speak too strongly to any of this. It says, if the contractor is delayed at any time in the commencement or the progress of the work caused by acts beyond the contractor's control, then it goes on to say you can seek additional time. So, and that's just language beyond the contractor's control. that's extremely vague, and I am sure it's going to be put forward in cases. It has not yet been interpreted as to whether that would catch a COVID-19 situation. Next page. Notice request for extra time. And there's a series of notices that will give you some language here. So in the event subcontractor is prevented from performing or otherwise has adverse impact to its work that are beyond the control of the subcontractor, subcontractor shall be entitled to an extension as its sole remedy. You have to give timely notice, and you're not entitled to any damages. So the no damage for delay language is here. And then the second paragraph is interesting. In the event the schedule and/or event during construction prohibits subcontractor from executing its work on a continual basis or in a sequence planned, subcontractor accepts this condition and shall not be entitled to any claim for extra costs, loss, or productivity. Subcontractor shall maintain continual flow of work at the fullest extent possible. So what that's saying, applying that to COVID, is, hey, if there's a problem where you cannot maintain the schedule, you have to do everything you can at your own cost without seeking additional costs to maintain the schedule. And I expect that general contractors will point to language like this in contracts to say, if they're being forced by the owner on the schedule that was pre-COVID, that they're going to be pointing to language like this to try to force it on you. And our position would be that that did not contemplate the act of God type situation brought on by a pandemic, which would absolutely entitle the general and the sub to additional time on the job. But they may be ultimately challenged. Next page. Another delay provision, talking about if you have substantial delay without your own fault, you must provide the general with notice. In this case, it's 5 days, and it's your sole remedy. More of the same. Next page. This is a notice of extra work. I'm sorry, a notice of extra costs. So subcontractor shall provide contractor with a notice of any circumstance which may otherwise serve as the basis for requests for an increase in price or extension of time within 5 days of receipt of the direction or the occurrence. So this gives some outs for a subcontractor with this language to say, hey, we got a circumstance here with COVID, and it's requiring us to incur additional cost and time, and we're putting you on notice of it. And again, failure to provide the notice is a waiver of that right. And then look for this next one, notice of unforeseen circumstances in your contracts or something similar. This one says within 3 business days after commencement of an event of delay, disruption, acceleration, or other impact, subcontractor must notify contractor in writing, promptly provide any requested information, and provide written notice of that situation. The remedies of additional time, which is provided here, is the exclusive remedy for any delay. So there's a theme there: prompt notice, waiver unless you've got notice, and then make sure that you are acting on it quickly upon learning of the circumstances. And most contracts will limit you to additional time, and you'll have to make better arguments than these contract terms allow for additional compensation. In summary, then, the next page. We're at the conclusion of our presentation. Job sites nationwide will look very different going forward, and for the foreseeable future, we don't know how long. Monitor the CDC and OSHA and state and local health departments for guidance. Assess your jobs upon returning and document any conditions that have changed. Anticipate and plan for labor and potential supply shortages. Review your contracts and insurance coverage not a bad time to check up with your insurance broker or agent to see if there's any situations that they can help you get ahead of, that they're seeing through other policies that they're dealing with. Read the contract provisions, as we talked about. Provide timely notice. And for those who are giving new bids, and there's work out there, there will be work out there. And every time a door closes, other opportunities arise, and there'll be more manufacturing capabilities implemented in this country and other work that will stem from this. But when you're doing your bids, the old reality is gone. There's going to be new timing and new schedules. Plan for potential supply disruption, and see if you can get some approved alternative products at the front end that are spec'd multiple more than you would usually, so that you can get ahead of it. Next page is some resources that AWCI makes available to you all that you should take advantage of, and there's some links to the OSHA guidelines and otherwise. So it has been Eric and my honor to provide this information to you. Hopefully it's been of some benefit for you. If there are any questions, we'll entertain them now, and you're free to email Eric or I with your questions after, and we'll do our best to respond to them timely when we receive them. And thank you.
Thank you, Rich and Eric. And Eric, we have a question that came in, and this goes back to when you were discussing what happens if an employee tests positive. So when an employee has had contact with a COVID-19 positive case and he or she does not present any symptoms, should he or she get tested, and should the company ask for the test results?
So in a perfect world, then the answer would certainly be yes, he or she should just go get tested right away, and then we can just know. But we also know that tests aren't as widely available as we'd like for them to be. Under the current CDC guidelines, that employee can continue to work if there's a potential exposure, provided that we take temperature before entering the job site, and that we continue to monitor in accordance with the employer's occupational health program, maintain social distancing, clean all areas, wear a face mask. That's a potential exposure. If we have a known exposure, there's got to be a little bit of kind of common sense and practicality applied to this. When we're talking about a known exposure, are we talking about, someone that, this employee went to church with, and maybe never actually came in close contact with? Or are we talking about this employee's child or spouse? And I think your reaction in those situations is going to be different when you've got someone that's asymptomatic. So I think if you've got an employee that's reporting that they may have had contact or they know they had contact, I think you want to investigate that a little bit further, ask some more questions, and then make a call based on what the likelihood of that employee bringing an asymptomatic transmission onto your job site is. And the overarching idea of it all is don't be, penny wise and pound foolish. If you suspect that there's a reasonable possibility that this employee could cause an infection at the job site, think about what the consequences of that would be versus the consequences of telling this employee to take a week or two off. So that would be my recommendation on that. Rich, do you have anything to add?
No, I think that's good. You can request the test, and if the employee does not want to provide it, they've probably got a legal basis to refuse. But you also can, have that person put on, taken off the job site and paid to stay home or paid to stay on a different responsibility under tight restrictions until they clear a 14-day quarantine period if they won't share.
Any more questions?
No, that is that's all that came in. So thank you for response to both of you on that. And on behalf of AWCI, we would like to thank Rich Capriola and Eric Coleman for your presentation today, and for the attendees who joined us for today's AWCI's Construction and Intex Expo Reconstructed. As a reminder, this program was recorded, and you'll receive a link to AWCI's online program library following the conclusion of today's broadcast. And be on the lookout for Friday emails from AWCI with our Intex Expo Reconstructed events through May 12th. And we actually just had one item come in. So Rich and Eric, if you can hold on a second here. So this question is based on strict following of CDC and OSHA guidelines as should occur, and the extreme contagious nature of COVID-19. Do you believe that the majority of job sites will eventually be shut down for some period of time?
I don't. This is Rich, and that's just trying to take a read on the political tone out there and the the potential risk level on a construction site. While some of the work is high risk, as Eric talked about, there are other industries where the risk is higher. We've seen the food processing plant, we've seen, schools and, large gatherings. I don't think that construction job sites are going to be shut down. I think that you're going to end up going to staggered shifts, potentially one trade in an area at a time, reduced productivity situations, and it's going to be difficult, and it's going to take everybody working together to make that economically viable for the players involved to do that work at a slower pace. But I don't think it's going to lead to closures on a broad sense. Eric, anything?
No, I agree. There will certainly be, I suspect, some job sites as things reopen and more people are coming into contact with each other, where you've got an outbreak at a job site. And we've seen in the news stories about a choir practice or a funeral that resulted in a mass outbreak. And it's not too hard to imagine that happening at a job site. But in terms of it happening in a widespread way, I think that would be surprising. I think it would be surprising because I think if they anticipated that happening, they would be taking a different approach. At least we would hope. So I think that the chances of it happening on a broad scale are not very high.
And I guess one thing we all can do as players in this industry is set a good example. And all it takes is a couple of media hits for job sites to become hotspots because people aren't paying attention, and they'll start shutting them down in a region. So whatever you can do to help your job site stay safe, not only for your employees, but for the other trades, speak up and, get everyone playing off the same sheet of music and following the rules. And that will protect everyone and everyone's livelihood and keep the jobs moving forward.
Thank you. And one last question. If our employee gets COVID-19, are we allowed to disclose their name to the builder? Isn't there a privacy law?
Yeah, that's probably beyond the reach of my current knowledge. I'll just tell you that right now. I'd have to look into that. I would have concern. There's there's privacy laws. You've got HIPAA situation, HIPAA requirements by medical standards. I think absent some specific determination that you can give the name of the employee, I believe you disclose the fact that you had an employee on this shift at this time who tested positive and came in contact with these people. so that they could do what they need to do without taking away the privacy rights of the individual. Eric, do you have any better thoughts?
I think that's right. I don't think you want to go telling an employee's name and personal information, but you can always ask the employee, for that permission, and if it's granted, make sure that it's done so in writing. But absent that, I agree. I think you maintain anonymity as much as you possibly can, while at the same time making sure that you give notice to others so that they can respond accordingly.
Okay. And if are either of you seeing a next possible big trend is employees suing employers over COVID-19?
Yeah,
so that
there
goes
are.
A little bit to,
go ahead, Eric.
Yeah, that goes a little bit to the workers' compensation issue and some of those things that are related. We will see those cases, and there are some that have already been filed. So we do anticipate some of those cases coming up. And to my knowledge, there hasn't been any, black line or red letter, whatever, specific decision that would apply to every case. But we do anticipate seeing some of those cases filed, and how those will play out, we don't know. But, is it going to become a widespread thing where employees all over the place are suing their employers? I don't think it will, but I do think it's going to show up from time to time. And I think the most egregious cases are going to be those where an employee contracts the illness and the employer failed to provide PPE, forced the employee to work in quarters that were contrary to CDC guidelines, and situations like that come up. I think you will see lawsuits coming out of those. And I think the best defense to those is going to be to carefully follow CDC and OSHA guidelines, and to document the steps that are being taken to comply with those guidelines and regulations.
Yeah, I agree. One thing, from a proof standard also, it's difficult for an employee to prove the source of that, contagion, where they got it. They're coming into contact with people all around. So just from a level of proof, it is going to be very difficult to get the science to back up that you got this on this job site from Bob, who was working next to you, because Bob didn't have a mask on. But that's going to be the standard they're going to have to meet.
And one last question before we wrap it up. Builders are requiring subcontractors to provide our employees' name, address, phone, and email before that employee enters the job site. Does the employee have to give the builder that much detail, that much personal information?
Well, that's going to be another privacy issue. I believe they're entitled to the identity of the people working there, and so they can keep track of and then potentially do tracing back if there's a problem. In terms of home phone and cell phone, that information, I would be hesitant to give it. I think you could make it available to the builder if there is a situation where health and safety require it be disclosed, or to give it over to the appropriate authorities at that time if they're doing contact tracing. Maybe that's a way to accommodate that, but that could be a state law specific. There is no one guideline that's going to be applicable there. Eric, thoughts?
Yeah, I think the name of the employees is something the builder's entitled to, and whether or not they're entitled to their home phone number and address, that seems like an overreach to me. I think that's information that you as the employer yourself have available within your records. I think that ought to be adequate for you to communicate to the builder, to the general contractor, that you have that information available should there be an actual need for it, but that it's not something you want to give out on a regular basis.
Okay, and that wraps up all of the questions that came in. So thank you to everyone for hanging with us. I know we went a little bit over, but Rich and Eric, again, thank you for taking the time, putting together the presentation and sharing this with our group. And everyone stay well and stay safe. Thank you.
Thank you.
Thank you.